Hi, I'm Andrew Spainhower with McMullin Injury Law, and I want to walk you through what it looks like and what to expect during the negotiation phase of your case. So this phase means that negotiations have commenced, and the way we do that is by getting your demand package sent out to the insurance company, which would typically start with a number. What amount are we demanding? And that's a number that you would have come up with your attorney and put in the demand. But once we get into this negotiation process, the most important thing is, assessing the value of the claim and making decisions. And at the end of the day, a personal injury case is worth the amount that the parties can agree that it's worth. And the way that that's figured out is which parties are most incentivized to get resolution. Is they just want it done now? Is that the claimant and us, or is that the insurance company? And then which parties want to avoid litigation and a potential jury trial the most. That's essentially how these case values are come up with, and obviously there's things that drive those values. During the settlement process, the most important thing is communication. As soon as we've already communicated about the initial offer that we make in a demand package, and then when an offer comes back from the insurance company, we want to keep you in the loop on that, and then have a discussion about what type of outcomes can we expect or anticipate, what maybe is the goal, and what happens if we can't reach that goal. Because at the end of the day, you'll want to make those decisions based on understanding what those options are, what choices do you have. For example, there will be times when the offer from the insurance company and it's their top offer and they won't budge if they're saying, hey, either take this number or go ahead and file a lawsuit. Well, we would want to be able to empower you with understanding what will it look like to file a lawsuit. How long would that take? And what's our reasonable expected outcome if we get to the end of that process? If we can't agree on a number between us and the insurance company, what number do we think we might get if we let our judge or jury or arbitrator decide? Because obviously that's going to affect your decision on what you want to do. As far as assessing the value of your claim, the biggest factors there are, the severity of the injury, the amount of the medical bills, the amount of the wages that you missed, and then the pain and suffering can be the gray area, the most subjective component of that, and it oftentimes can be the biggest component of a case as far as the value. And that's something specific to your story. The pain and suffering, for an Olympic swimmer that's unable to participate in the Olympics that year because they were in a car accident and had to give up training for months, is very different, even if than somebody that the primary hobby is watching Netflix. Even if they had the exact same injury happen, the way that it affected, their lives and their story becomes a lot different. With dealing with insurance companies, not every insurance company will approach a settlement negotiation process the exact same. That can be different. And that's where we want you to be able to rely on the input from your attorney as far as what to expect and what we should do. The role of your attorney there is to keep you advised throughout that process so that at the end of the day, the decision maker can be you, and that you can be empowered to know what options you have and whether or not you want to go ahead and settle or whether or not you want to continue forward and explore those other options like litigation. The art of negotiation might be a little different based on the type of case and then also based on the type of insurance company involved, meaning even a case where the same injuries were suffered, maybe it's minimal injuries. Some neck strain, back strain, recovered in the matter of only a few months, was all better, back to normal. How you would negotiate that case as far as aggressively versus potentially trying to reach a quicker resolution could be very different based on, was this a semi-truck that hit you? Because the incentives are different. The semi-truck knows that they have these huge insurance policies and so much more to lose, and also a jury's not going to be sympathetic to them. Things are a little different if you get in the same crash, but it's with a little old lady, driving her 1990s Honda Civic. You're going to want to approach that negotiation process a little bit differently because the eventual outcome of that same case could be vastly different. So how to know when to accept a settlement or not is a big factor during this process. The most important thing is that your attorney is able to get you the maximum amount that's fair and reasonable for what happened to you under Utah law. We can't make up these pie-in-the-sky numbers. They come from somewhere. And we've talked about those things that affect the case value, but your attorney should be able to walk you through that decision-making process of knowing, well, how confident are we that that's really the insurance company's top number? how confident are we that if we accept a policy limit offer from the insurance, that there was not more on the table and it was not worth seeking a lawsuit against the individual driver? Are there other insurance coverages that will apply after this initial settlement? That would obviously really affect, our decision making, what we want to do. When we're making that eventual decision, you'll want to understand the trial process and the litigation process so that you can properly assess how long are you willing to drag this out. There are times when it might be much in your best interest to take 70 cents on the dollar now rather than, go into litigation and wait a year to get your check. The same thing goes for the insurance company. Those guys like being able to hold the money and gain interest on their money. And so they're looking to resolve a claim when they feel like, hey, we can pay X% of what we really think it's worth now, but just to be done with it and be able to close our file. And sometimes assessing the future risk of that claim and how long it might take can vastly, affect how likely we are to go ahead and accept a settlement, whether we feel like it's a fully fair number or not. At the end of the day, we want you to be able to be the boss and make those decisions, but communication back and forth with your attorney is key. And your attorney, keep in mind, has negotiated hundreds of cases, of injury cases. And so that's going to give us a bearing, much like comparables in the real estate market. That's going to give us some insider knowledge as to what your case should be worth and how to get you to that number through that negotiation process. So, we want you to listen and trust your attorney, but we want you to be able to have the information and make the final decision. Frequently asked questions during this process would include, how long does it usually take to negotiate my case? So the first step of that is we send out a demand package with typically a 30-day time limit. And Utah law says that the insurance companies are to respond during that amount of time, as a reasonable amount of time, to a demand package. There's not teeth to that law, and so there are times when it can take a little longer. We want to try to keep the pressure on and get them to do the right thing and evaluate, without wasting a ton of time and giving us a reasonable offer in a timely manner. But depending on the type of case and how much we want resolution right now as opposed to later, that may be fudged a little bit. There are times the insurance company will come back with an offer in only a week of a demand, but there are times that 30 days could become 60, and there are things that we can do to try to avoid that, but only so much. And so that's something we want to consider carefully, whether we just cut bait and file a lawsuit because they're taking a little longer than we'd like. Once we get an offer, it's possible that your case could move forward pretty quickly. If we feel like they've come back in what we would consider to be a fair to reasonable range, where we now have an opportunity for us to come down from the amount in the demand and give them a counter offer to come more to the table from their initial offer, and perhaps we now come more to the table there, and we're essentially able to get to a meeting of the minds fairly quickly after that first offer. There are times when that doesn't happen, and it's typically when there's a main issue in the case that we're seeing completely differently from an insurance company. If we think that the fair and reasonable value of what happened to you from your injury is $100,000 policy limit, and an insurance company comes back and thinks that the fair and reasonable value is $18,000 because they're not honoring a $40,000 surgery as being related to the crash or not, that's a major issue, and that's likely not one that just over the course of a few counter offers is suddenly we're going to agree. That's something where we may have to go back to the drawing board and re-present the information to them on that issue, gather additional evidence on that issue, or file a lawsuit and litigate because of that issue. So there are times that, a week after that first offer, we could potentially have a case resolved, but there are definitely times where it could be months, and if it goes into litigation, potentially years. Why is the insurance company, lowballing the value of my case is a question that people typically have. The important thing here is to ideally don't take it personally and feel insulted. That is the insurance company's job. They're likely going to lowball your case. Same as if you hadn't hired an attorney at all, they probably would have offered you $500 for your case. So their job is to resolve these claims in the way that saves their company the most money. And so any possible nitpicky thing that they can look for, they will do it. They don't know you personally. We're trying to, through our demand package, to help them get to know you personally. At the end of the day, they're making dollars and cents decisions. And if they think that they should be able to get away with resolving your case for a very low ball offer, they will try to do that. And so it's important to remember when the attorney calls and goes over that initial offer, to not freak out. We try to, it's an emotional time, but we try to remain as unemotional about it as we can so that it doesn't get in the way of getting us to where we need to be. There are times when an initial offer could come in terrible, and over the course of the next month of negotiating back and forth, presenting additional information, that we can still get to the place where we want to be that does make more sense and can become a win-win where we would actually want to go ahead and resolve the claim. So that's why they lowball your offer. They're trying to save money wherever they possibly can.